No problem. We're set to go live here in about 15 seconds. I'll let you know once we're live.
Okay, good.
All right, Mr. Chavez, we are now live.
Good. Okay, folks, good morning again. We are on the record, and today's date is March 18th, 2021, and I am Stephen Chavez, the city's land use hearing officer. This is a time-sensitive quasi-judicial administrative appeal from a decision of the zoning hearing examiner, and the number is AC-21-2. This hearing is also being recorded by a certified court reporter, Ms. Rebecca Fella. Good morning again, Ms. Fella.
Good morning.
The procedure for this hearing is as follows. The appellant will make an argument that if there is anybody that would like to challenge that argument, that person or persons can make an argument as well, a short argument. The city planning staff, Ms. Patton Quintana, can, if she chooses to, she can make her record on behalf of the city. The appellant, Mr. Turner, will be allowed to make a closing rebuttal argument if necessary. I will swear in Mr. Turner before we get started. And I just for the record, I note that Mr. Turner did submit some supplements to the record, and I will go over those supplements. I will include all of those supplements, Mr. Turner, into the record. And you submitted some photos, as well as a May 2017 ZHE decision that is very similar to this application. And 4 letters of support, it looks like, from some neighborhood associations and some others. Is that correct, Mr. Turner?
You're muted, sir. You're muted.
Thank you. Can you hear me now?
We can.
Yes, thank you, Mr. Chavez. That is correct. Those items and documents were submitted as additional evidence for the record.
Do you have any questions before we get started?
I do not.
Okay, let me swear you in, sir. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Good. Let's get started. Go right ahead. I have reviewed the entire record as well as the supplements that you've provided.
Thank you, Mr. Chavez. In a review of the record, we have filed this appeal timely to the denial of a variance request for the charter school solutions, specifically for the Albuquerque School of Excellence, which is located on Lomas Boulevard Northeast. The denial by the ZHE for the variance brings up several issues that we addressed in the appeal letter. And specifically, we state and address how the ZHE erred in his decision, that we believe he erred in his decision to deny the variance. And also that not only did the ZHE err, but we describe that he exhibited an abuse of discretion and went outside of his scope of authority, as explained in the letter of appeal. Furthermore, we believe that the ZHE's decision was arbitrary and capricious, and we are here on appeal to ask for relief based on the actions of the ZHE, the errors that were made in applying the IDO, and the decision that was made without basis or findings to give an explanation for that denial. We would like.
I thought he did give an explanation for the denial, and that was in I think finding number 8 or 7, where he specifically said that the request would would materially undermine the intent of the IDO.
The intent and purpose, and we are aware of that. We noted that. However, that, as explained in the appeal letter, is a conclusory statement that is copied out of the IDO, literally. That phrase is directly copied out of the IDO, and don't believe that that constitutes any explanation or reasoning beyond what the IDO already says. Undermining the intent and purpose of the IDO is one of the criteria to be looked at by the ZHE in determining approval of a variance. However, to base the decision of the variance denial simply on the wording that's existing in the IDO without any discussion or explanation, we believe is arbitrary and capricious.
Are you finished? I'm sorry.
Yes, I am. Thank you.
So the applicant is the Charter School Systems, correct?
That's correct.
And
Charter
are
Public.
they a New Mexico company or out-of-state company? I mean, not that it matters, but they're a company, correct? I guess that's my question.
Excuse me, Mr. Chavez, can you repeat that one moment?
I'm sorry. Charter School Systems is a limited liability company or a corporation?
I can't. I believe they are a limited liability corporation, but I'm hoping the head administrator is on the Zoom meeting and could answer that specifically. I can't remember. Let me look, if you don't mind. I have the file next to me.
Sure.
Let me look and see. We typically do background research to verify the ownership and look at corporate status as part of that. And I think they're an LLC. I just want to double check. So I can't remember.
That's okay.
I'm gonna say they are, but I would like to ask
Okay.
Mr. Mustafa Mayek, who's the principal and head administrator. He wasn't invited to the Zoom meeting, and I'm hoping he's here and he can answer that.
Okay. If he's not here, we can move on, and then I'll call him in a second. I have a few more questions. So CSS owns the land essentially.
That's correct.
I saw that in the record. It's at somewhere in the record, page 17 of the record. I think it was in your argument. Is that correct? Do they own the land?
That is correct.
Okay. And it's a total of 4.99 acres, correct?
Correct.
Okay. And it used to be the Albertsons. As I recall, it was an Albertsons over there a while ago. And there's an existing sign that Albertsons utilized at the time, correct? Is that the one you're intending to replace with the LED electronic sign?
That is correct. The photo that was submitted to supplement the record that you should have received a couple of days ago shows the old sign that Albertsons utilized, and that was since removed. And
it's been removed so far. Okay.
It has. Yeah, it has been removed, and that was one of the reasons for submitting the photo, is to help the LUHO understand, based on the photos in the record, which is the current layout and development at the property now. That corner where the sign was, so it's the older photo from Google Street View that was submitted, and you can see the Albertson sign. I'm sorry, it's School of Excellence, but it's a dilapidated sign. It's very obviously old and worn. That sign has since been removed, and that area, if we look at the more recent photos that were submitted with the ZHE case, and I apologize, I'm sorry, I know a lot of them are sideways,
Okay.
which is annoying for me to see. It just makes it more difficult.
I'm used to it, believe me.
But we can see that recently, it was probably within the past 2 years, the school built a new building, a new classroom building, and they located it in the parking area that was along Lomas, fronting the street. And so they placed the building with almost no setback within the regulations of setbacks. And that building now fronts the street, therefore sort of hiding the parking behind. During that construction of the building, part of the process was to get a grading and drainage plan approved by the city. And working with the city, the engineers were required to create a ponding area in that corner, essentially where the old sign structure posts were. And so that corner of the property at the ingress egress has now become a large ponding area, a deep ponding area that functions to retain water on the site rather than let it flow out onto Lomas, which was what was previously happening on the site, and does not comply or did not comply with the new hydrology regulations for ponding requirements during the first flush of the 100-year storm. So that corner has now become a ponding area, but was the location of the old sign, or essentially where the old freestanding sign was for Albertsons, which then became Albuquerque School of Excellence's sign. Based on the dilapidation of the sign and the location, the school removed the sign. And this request is to allow a replacement freestanding sign within the limits of size in the IDO, but below that freestanding sign with the school's name is a smaller 50 square foot electronic sign for messages.
Okay, so the proposed sign is going in that same location, or are you going to use that structure, the foundation structure, for the proposed sign?
No, that has been, since been removed. It is not usable to locate a new sign exactly where the old sign was
because of the ponding.
Because of the ponding, and the corner of the building is now in that area as well. The design and development of the site to add the school building was to add a 2-story building and take advantage of the vertical capability for square footage. And so the building is a 2-story building, and fit within, the footprint next to the old Albertsons grocery store, which has been renovated and remodeled as a school. But that building created the need and necessity for a grading and drainage plan and for new ponding requirements, which the school complied with in order to get their building permit and build the new classroom addition.
And has CSS looked into creating a LED electronic sign outside of the 660-foot prohibited area? It sounds like you can't do it with a standalone sign, but can you possibly do it with a sign attached to the 2-story structure?
As a wall sign, Mr. Chavez, is that what you mean?
Right, a wall sign.
I don't think the school had envisioned a wall sign message board in their plans, thinking, putting the LED sign below the large sign would face the sign to Lomas traffic east and west, if they were to use a wall sign, it would literally face directly south,
Right.
and not serve the purpose as for what they need. It would be advertising to the neighborhood,
Right.
and that's something. Yeah, it'd be advertising to the neighborhood on Lomas.
Right.
Sorry, you guys, can you start?
Rebecca, you've paused. Hold on a second. Rebecca, can you hear me?
Mr. Chavez, it looks like maybe her internet connection may have kind of gone out a little bit there.
May have failed.
There she
Here
goes.
you go. Rebecca,
I didn't get any of that, no.
We stopped. We stopped when your internet connection froze.
Okay. If the last thing I got is they were to use a wall sign, it would literally face directly south
Okay.
and not serve the purpose for what they need.
I think that's where it basically ended.
Okay. Did you hear Mr. Turner?
I did, and I well, that was almost everything I said. The only thing that wasn't included was that the sign would face directly south and would be seen mostly only by the neighborhood, and that is something we are trying to avoid. Facing the sign directly to the neighborhood is not the intent of the school.
Understood. So now explain to me why you included the May 2017 ZHE decision.
Thank you, Mr. Chavez. I think that decision is very relevant. The zoning code was amended with it's Council Bill 0-11-69. In 2011 is when the city council amended the sign regulations pertaining to and updating the regulations for electronic signs, and that's when added restrictions to new off-premise signs, electronic off-premise electronic signs were added to the zoning code, and there were lots and lots of language in the ordinance that controls the brightness and how that's measured, the changing of messages, and in this amendment, which is again it was in 2011, that is where part of that ordinance incorporates prohibited areas, and that's where the streets of Tramway, Griegos, Alameda, Unser, and Coors were specifically called out as prohibited areas within 660 feet of the right-of-way for electronic signs. And since that ordinance was passed, a business, in this case, the hotel on Rio Grande, went and tried to obtain a sign permit for a digital sign in 2017. They were told by zoning, you can't have a sign because you're electronic sign because you're on within 660 feet of Rio Grande Boulevard. And I think that was probably one of the first times the city, exercised that new regulation, and the property owner asked what they could do, and they were told you can get a variance. And so they left the city and talked to the sign company, and we received a call to apply for an attempt to obtain a variance to the 660-foot distance requirement from Rio Grande. And that's what we did. We submitted the application and met the criteria.
So why is that relevant today? I mean, why is that relevant for purposes of this appeal? And I guess that's my question.
Sure. That's relevant for this appeal because based on the response, well, the reaction from the ZHE during the hearing, whether or not he could hear this case for a variance if a sign is prohibited. He asked that question, and we at the hearing on record explained why we believed that the variance was appropriate, and that was based on the definition of a variance, and that was also included an explanation of the dimensional standard that we were varying from the strict literal interpretation of the 660 feet.
So it's your claim that, I'm sorry to interrupt, but I'm just trying to speed things along.
That's okay.
It's your claim that the variance that was applied for in May 2017 was a dimensional variance to the 660 prohibition in section 512H, I believe.
That's correct.
Rather than a use variance, correct?
That's correct, Mr. Chavez.
Okay.
Yes.
And then I noted that he referenced that the existing sign, and we're talking about the May 2017 case, the existing sign was a non-conforming use. He made a finding of fact regarding that. Was that non-conforming sign, was that a non-electronic sign?
I actually, Mr. Chavez, I believe, if I remember correctly, I believe the nonconformity was the height of the sign, that was the existing sign. It exceeded the height allowed.
I see. Okay. Was it an electronic sign that was
No.
replaced by an electronic sign?
No.
Okay. So it was a non-electronic sign that was being replaced by an LED electronic sign.
In a different location. Yes,
Okay.
that's correct.
Okay. And the I think you can answer this because you're very knowledgeable regarding the zoning code. The definition of a variance has never changed in the IDO. Would you agree with that?
I would agree with that.
Okay. I can tell you that what the ZHE did in 2017, he essentially acted contrary to the IDO in two ways, because he didn't meet the definition of a variance. I think that's number one. And number two, it doesn't meet the definition of a non-conforming use for a variance. If you look at under section 6-8F, I think, in that area, you cannot change or convert a non-conforming sign with a LED electronic sign if it is in a prohibited area. I mean, that language is very express. It's very clear, and I'm guessing that language was still existed in May 2017. So I mean, I understand you would like to use it as precedential value, and it's in the record for the city council, and I'll make reference to it. But I don't think I can. I don't think that decision is binding on the city council, because it was never appealed, I assume, because all you submitted was the ZHE decision. Can I assume, is it a correct assumption that it was never appealed?
That's correct, Mr. Chavez. It was never appealed, nor, to my knowledge, have there been any complaints since then.
Right, and the issue isn't with complaints. I understand that nobody is complaining about your proposed use other than the IDO itself. I mean, the language of the IDO. So yeah. I get that. Everybody supports this proposed use.
Okay, thank you, Mr. Chavez. And I think you're asked. That's a very good point to bring up. Is that there was no. Yeah, it reminds me of, if we look at the doctrine of administrative gloss, and if there was legislative interference, after the fact. Does that make any sense?
No, I understand the doctrine of administrative gloss. Administrative gloss, though, is only applicable when there is vagueness in the language. And secondly, if the language is vague and the city places an administrative gloss or administrative spin on that vague language, it is not binding on the city council unless the city council made that act. That is, unless the city council reviewed it and determined this is what we are going to do because this language is vague. I don't think we have that here. It's not ripe for that issue because the city council has not actually reviewed an appeal yet regarding a issue like yours, Mr. Turner.
I agree.
Great. Is there anything else you would like to add? You had indicated there's somebody else that would like to testify. Before that person testifies, I would have to swear that person in. Is that person on the line in our Zoom hearing? Mr. Turner, do you see that person?
I only see me.
Okay. There is a Miss Lopez, Angela Lopez. I don't know who she is, but Miss Lopez, would you like to testify in this hearing? Okay, looks like no.
Testify.
Oh, I'm sorry, Miss Lopez?
That's okay. Good morning. I would be happy to testify, Mr. Chavez, if that's okay with Mr. Turner. It's up to him.
Absolutely. Thank you. It is okay.
Ms. Lopez, let me swear you in. Okay, can you please raise your right hand? There you are. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury, ma'am?
Yes, sir.
Good. And please state your full name for the record and tell me who you are.
Absolutely. My name is Angela Lopez, and I am the Albuquerque School of Excellence Outreach Coordinator, Human Resources Coordinator, and COVID point person.
Got it. Okay, and feel free to go ahead.
Okay, the reason I'm here is Mr. Ayek actually is in a meeting with the Secretary of Education right now, and he wanted me to present our case. That sign has been in existence with just a flat, Albuquerque School of Excellence logo on it, and it's been a demand from our community as well as our parents to have a more informative way of telling parents what's going on within the community, within the schools, etc. And our PTO has been fundraising to help pay for the sign. And we would really like to honor the demands of our community and our parents and get this information across. We've received letters from not only the president of the neighborhood association, but also from residents that are living behind us, as well as in front of us, of where that sign would be projected in the middle of the day. And they're both in support of it as well. So I wanted to present that forward and make sure that that is known, that really there isn't anything arguing against the sign from our community. We have more support of it. And furthermore, if you drive down Tramway, there's many electronic signs that are a little bit distracting, I would have to say, whereas this one is for a school, it has a purpose, and it's not distracting when it tells you the time, the day, and whatever the event is that's going on at this school. So I'd be happy to answer any specific questions, but that's what I would like to get across.
Thank you, Ms. Lopez. I appreciate your testimony. The issue, though, is a legal issue, and that is the IDO. And so this is technically a prohibited area. And Mr. Turner takes the position that this is a dimensional variance rather than a use variance. A use variance would be something to allow, a variance to allow a use that is not allowed in that area. If it is a use variance, it's prohibited. It can't be placed in that area, regardless of who supports it.
Sure.
Yeah, so it's really an issue of the IDO and how it's applied. But thank you so much. And I do have 4 letters that Mr. Turner submitted that I have included in the record for the City Council. And those letters, I don't have them in front of me, but I believe there are 4. There are 4, correct, Mr. Turner?
Yes, I believe there are 4. Yes.
Okay. Good. And Mr. Turner, I have a couple of questions for you, if I may ask you some more questions, and then I'll let Ms. Patton Quintana address the record if necessary. You argued earlier that Mr. Lucero, the ZHE, had essentially abused his discretion. I think I know what you mean, but can you please explain and elaborate on what you believe the abuse of discretion was? And it was an abuse of discretion because you believe that he should have addressed the criteria for the 5-prong test for a variance, and rather than addressing the 5 prongs, he essentially just made a finding that this materially is contrary to the intent. I'm paraphrasing, but materially contrary to the intent of the IDO. Is that your position on abuse of discretion?
Yes and no. I think I'd like to expand a little bit on that. You know, as we mentioned in our appeal, we believe that an abuse of discretion is established if the agency or lower court has not proceeded in the manner required by law. The order or decision is not supported by the findings, or the findings are not supported by the evidence. And again, the findings are very vague. As a matter of fact, we see the literal phrase that was used to finding number 9, I believe it is. Finding number 9 doesn't give any explanation, and there's nothing to support that. It leaves the school and myself wondering how this undermines the intent and purpose of the IDO. And as also mentioned in the letter, there are several sections under intent and purpose that are all different and have different meaning. And none of those sections, and looking at the purpose of the IDO, 1416-1-3, there are 12 subsections, A through L. And so without referencing even one of those, and it leaves the school and us wondering what specifically undermines it. Is it the entire IDO? Is it a public safety? Is there injury that the ZHE felt there was potential injury with the sign? Does it conflict with past interpretations? Does it violate policy? Does it, the list goes on, but there's 12
right.
sections.
No, I get it. I see what you're saying. It does look like the findings are a little vague. I'm guessing that he came to the conclusion that the variance would materially undermine the intent and purpose of the IDO through one of the prongs. I think it's the 4th or 5th prong of the variance test, and the facts to support that. He didn't state the facts to support that, but I'm assuming, and I don't know if it's presumptuous of me to make this assumption. I'll look into it a little closer, and when I draft my recommendation to the city council, I will elaborate on that. But it seems to me that what the ZHE determined was that the definition of a variance does not allow uses that are otherwise not permitted. You can't use the variance to create a impermissible use in a area that's been prohibited, that a certain use has been prohibited in. I'm guessing that's what he's doing, but I would agree that the language that he chose, or that the facts that are lacking in his decision don't lead us to that point. So I take note of that, certainly.
Thank you. And we feel the same way, as that we can only assume. And I think it wasn't until it was well after the appeal was drafted, where city staff wrote a memo and responded to the appeal, where there's finally a mention of maybe maybe there's a mention of whether or not well, there's not a mention. It is in writing in the response to the appeal by city staff that a prohibited use, asking for a variance to a prohibited use, and I use the word use in quotations, is never allowed via a variance, or something to that effect. It's in the record. And
I see it now. Right. Yeah, I get it. It's a memo. I think you're referring to a memo in the record dated February 9th, 2021 from the planning director, Mr. Brennan Williams. Is that the memo you're referencing, sir?
That is correct. And that is the first inclination that the school and we received to know, oh, this might be what undermining the intent and purpose of the IDO means. And so now we finally narrowed it down just based on the memo to understand it's not in the decision. If it was clear, if the decision was clear and it gave that explanation, then it would be more understandable in our appeal to direct the appeal to a certain decision in that area of the zoning code or the IDO, that the request was improper because this is a prohibited area. Therefore, we were asking for a use that's not allowed. And
wait. You know that it's a prohibited area because it's in the IDO.
That is correct. But what we know is that the property zoning allows signs, the use of the signs, and many different kinds. I mean, there's wall signs, projecting signs, monument signs, freestanding signs. An electronic sign happens to be one type. We didn't believe we were asking for a use that wasn't allowed. We believe we were asking for something that has a dimensional restriction.
Yeah,
although
I think I understand that issue. I mean, you're claiming, as I said earlier, this is a dimensional variance rather than a variance to a use. I get that. I see that. So I think I normally would remand something like this back to the ZHE, but I think there are enough facts in the record that I can actually make a recommendation to the city council. And whether they approve my recommendation is entirely up to them. But I think there are enough facts that I don't have to remand the matter back to the ZHE to review this again. And I will draft a recommendation. Mr. Turner, I don't want to cut you off short, but you're kind of repeating yourself again. I can give you some rebuttal time in a moment, but are you finished with your presentation, sir?
Yes, I would like to add just one thing for the first the part of the presentation is that the IDO, the construction of the ordinance and the language, it's very clear in regulations like this where there are prohibited areas, whether or not it's for a sign or for another kind of use like retailing of liquor. Throughout the zoning code, there are other regulations that say, this use is prohibited in the following mapped areas. This use is prohibited along, in the Monte Vista Historic District. This use, and I think that is and shows that the way the construction of the language for electronic sign prohibitions on the 6 different streets in the city, it doesn't say that. It doesn't say signs, this use is prohibited within 660 feet of tramway or unser. It gives the dimension that this use is prohibited, or this signs are electronic signs are prohibited within the 660 foot of a right-of-way of tramway. But I think there is a difference by not using the word use, as the writer, the authors of the IDL have chosen in many other areas of the IDL, the code, to construct the language differently to where it says that this use is prohibited, rather than signs are prohibited, electronic signs are prohibited. I think that does have meaning as it relates to this case.
Well, that's a creative argument. Certainly, I will take note of it. I disagree. I think that an LED electronic sign is a use. It is implicitly a use under the definitions in the IDO. So regardless of whether it's named as a use or not, I think it is a use in terms of zoning prevalence and even expressly under the IDO. But I will take note of that, and I will let you make a closing argument in a moment. I'd like to move on. Mr. Turner, Ms. Patton-Quintana, is there anything you would like to add to the record?
Good morning. No, sir.
If so, I need to swear you in.
No, I'm good.
Okay.
Thank you.
Thank you. Mr. Turner, do you have any questions for Ms. Patton-Quintana? I normally wouldn't allow cross-examination, but I will allow you to address Ms. Quintana with some questions if they're reasonable questions.
Yes, Mr. Chavez, I would like to ask a question.
Hold on a second. Ms. Patton-Quintana, let me swear you in, please.
Yes, sir.
Okay, and I appreciate you cooperating with this. I have discretion, but normally I wouldn't allow the questioning because you didn't testify. But because we are not in a courtroom and these are quasi-judicial hearings, I'm going to use that discretion to add to the record if we can. Ms. Patton, let me swear you in. Please raise your right hand and let me know that it's raised.
My hand is raised.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you so much. Go ahead, Mr. Turner.
Thank you, Mr. Chavez. Ms. Patton-Quintana, how are you doing?
Good. Good morning.
Good. I have one question. As a ZHE staff member with many years sitting in on hearings and doing ZHE applications, whether they're conditional use or variance or non-conforming use, etc. The city typically each month receives applications, and they are reviewed at the time of submission, but they're also reviewed by staff after they're submitted for completeness and also to determine their validity as it relates to the IDO or zoning code. Isn't that correct?
Yes.
And typically during the process after an application has been submitted and the fee has been paid and the case moves forward to the hearing after they've been analyzed by city staff, including zoning, who acts as the ZEO, as designees for the ZEO to determine whether an application is correct and whether or not somebody's applying for a zone change when they can't do that. When after the case moves forward and goes to hearing, typically the city does not decide at the hearing whether or not an application could be heard. Is that correct?
Ms. Patton-Quintana, I'm not going to allow you to answer that question. Mr. Turner, that would be a question for the ZHE, and he's not here, and it would be improper if he was here. So I'm not going to allow that to occur. I think that's an inappropriate question.
Okay.
Please just ask factual questions that Ms. Patton-Quintana can answer.
Okay. Thank you. I think that's all. I think the first question suffices. Thank you.
Is there anything you'd like to add in a rebuttal or in a closing argument?
Yes, Mr. Chavez, thank you. I know the city has made a great and major change from going from the zoning code that was in effect from 1959 to 2018 to now the IDO, and I think there are notable changes in the way that the ordinance was written as compared to what happened in 2017 when the application for variance to the same section of prohibited areas was requested. I note that in the IDO, as opposed to the zoning code, in the IDO, signs are regulated under the development standards, and in the zoning code, signs were listed as a use, as an enumerated use within the zone. If we look at the use table of the IDO, I believe it's 5-1-1. I'd have to, but it's the use table.
Right.
You don't find signs. Signs aren't listed as a use. I think we can all agree that a sign is a use on a property, but I think the way the IDO language is constructed to regulate signs and to show how they're regulated in the specific section, we go to development standards. So I think that also furthers our our standing that this is a dimensional request. It's not to ask for a use that is not allowed, because it is allowed on the property, and we tried to make that clear, just not in the 660 feet. And we are very close to locating the sign and to be within compliance, to be outside of the 660 or at the 660. And I think looking at the zoning code and what a variance is for, this is the only relief that the school has to acquire a sign, where prior to 2011, prior to the ordinance that amended electronic signs, this would have been allowed on the property and in any location, even close to tramway. Again, noting that the property is not on Tramway Boulevard. It's actually on Tramway Road and Lomas. But it is, there's no doubt, it's undeniable. They are in the prohibited area of 660 feet. However, prior to the amendment to the ordinance, the sign would have been allowed by right. And
But that's not relevant, is it? I mean, we're under the IDO, and the IDO is what is applicable here, regardless of what history tells us.
I agree. However, it's still true that the sign can be on the property legally with significant hardship on the school. And if you look at the definition of the criteria for variance approval, the intention is to relieve hardship. And then I think this is a great example. It's not that the school wants the sign on Tramway. That's not their intent. And the property has been developed for several decades. So the physical layout and especially I'm focusing on the ingress egress of the property onto Lomas was established years ago, and to alter that ingress egress or to relocate it would be an extreme hardship on the school to get the extra feet required to be outside of the 660 feet. And so if we look at the idea for any kind of relief for something like that, knowing that the school can have the sign on the property legally, we believe that this is the minimal necessary to overcome that hardship. And we are asking for a small dimensional standard, half of what was asked for on the first case that was heard by the city on Rio Grande. And yeah, I do think there is an importance that this is a school. It's a little bit different than we have the Walgreens a block away on Tramway and the CVS with digital signs on Tramway. And ironic enough, the Hinkle Family Fun Center has a digital sign on Tramway, and they're in use. So
yeah, I can't consider that. I mean, certainly that sign may have been approved prior to the IDO. I don't know the facts. I don't want to get into that. Mr. Turner, I am only allowed by what is in the IDO. And so I have to review, and as you know, my authority is advisory. And so I have to review what's allowed in the IDO, and I can't go beyond that. That's for a different arena. I have to determine whether or not the ZHE erred in terms of applying the IDO or in terms of reviewing the facts, essentially. So I can't go beyond that realm. And it seems to me you're making a political argument for ignoring what's in the IDO. I can't do that. I wish I could. I don't have that authority, nor would I want that authority. So I'm perfectly comfortable with reviewing what's in the IDO. And so you have gone well beyond your time allowed. So please follow up and close this if you can.
All right, thank you, Mr.
You muted yourself, sir. Mr. Turner?
He's up.
Oh, okay.
No, Mr. Turner? Mr. Turner? I think he accidentally turned himself off.
Sorry, a technical problem. There we go.
Yeah.
We would just close.
Can you increase your volume?
Oh, I think so. Is that any better?
A bit better. I'll increase mine. And Rebecca, can you hear okay?
Yes, I can hear him. Just speak up.
Okay.
Good. Yeah. Good. Go ahead.
Very good. we would just close by saying that according to our letter and the reasons given, we would ask the city and the Lujo to reverse the decision for the denial of a variance, or if they're not inclined to remand the case back to the ZHE for an additional hearing for new evidence and new testimony to be heard. But we respectfully ask that be done in response to our request for appeal. This will relieve the school of hardship of not being able to put a sign up and use it in a way that doesn't advertise services, doesn't advertise products. It's simply to provide information to the general public and the school and staff.
Okay, thank you so much, Mr. Turner. It's always a pleasure having you here. I know that you've been around for a long time. Thank you again. We will close this record. Mr. Turner, I will submit my recommendation to you and to the city simultaneously, and it'll be probably within a week, but I have 15 days, okay?
Thank you.
Thank you. Let's go off the record. Bye-bye.